plans to sue the president. This comes as the High Court convenes on Wednesday to hear a case in which lobby group Katiba Institute is challenging the gazettement and swearing in of 34 judges last week, with 2 more cases awaiting the court's direction. Our senior political reporter Murimi Mwangi has the details.
3 days after the swearing-in of 34 judges at State House, Nairobi, and pressure continues to mount on President Uhuru Kenyatta to also gazette 6 other judges whose names he left out despite their vetting and approval by the Judicial Service Commission.
We reiterate that the president had no locus, had no reason, none in law, nor constitutionally, to deny the appointment of those judges. Some of those magistrates have done tremendous work.
The 6 include 4 sitting High Court judges, namely Justices George Odunga, Professor Joel Ngugi, Agre Muchelule, and Weldon Korir. Also not gazetted are current serving magistrates Evans Kiagi and Elizabeth Cheruiyot, persons whose reputation lawyer Dunstan Omari says is at stake under likely public ridicule, as the president is yet to publicize any individual queries he has against any of the 6. Omari now waiting on the green light from the Judges and Magistrates Association to sue President Kenyatta in court.
In the proceedings, if ever it will happen, is the president now going to give the complaints against the 6 members? My clients, none of them has been given the reasons as to why the president decided not to appoint them.
It's not right and it's not justifiable or excusable for that information, for whatever information to be used at this stage after the vetting process has taken place. If the information existed, our right to a presumption is that that information was neither substantiated or enough to deter the appointment of these judges as to the next level.
Nakuru-based medic Magare Gikenyi has already petitioned the High Court to block the Judicial Service Commission from assigning any duties to the 34 recently gazetted judges who were sworn in last week until his suit against the exclusion of the 6 is heard and determined. This as the High Court reconvenes on Wednesday to give directions in a separate case where lobby group Katiba Institute had sought orders against the swearing-in of the 34 judges last week, orders which had not been granted by the time of the Friday swearing-in ceremony. Kenyatta has been under fire for perpetually ignoring court orders, including one in February 2020, to swear in all the 41 judges. Some observers are skeptical about Kenyatta's keenness to the ongoing litigation following his decision to only swear in the 34, putting Chief Justice Martha Koome on the spotlight. Murimi Mwangi, KTN News.
Right, just as my colleague Murimi Mwangi has said, that the decision by the president to leave out 6 judges and just to appoint 34 has put the Chief Justice Martha Koome on a spotlight, and the fact that she attended that swearing-in ceremony. So let me bring in Joshua Kipto, who's a lawyer, just to try and explain to us what is next. It is a discussion that definitely will not end when it comes to the decision by the president to leave the 6 judges out. And Wakili, good morning. So let me begin first by just picking your mind on that decision by the Magistrates and Judges Association, plan to actually sue to take the president in court in terms of suing him. How realistic is this, and will it be successful?
Thank you very much. I think the issue is not whether it's successful or not. The issue here is it is a question about the defense of the Constitution. I want us to have some clear agreements where there is no argument, and I haven't seen anyone arguing against that. For example, the president does not have the power to cherry pick or to choose who to to swear in and who not to swear in. As soon as the JSC process is complete, and if you saw the statement, I think the CJ was trying to balance by saying it becomes functus official. Once it was done, it was done. The president has representatives in the JSC. If there were issues to be substantiated or allegations to be raised, the AG represents the president personally. You have 2, 3 other commissioners appointed directly by the ruling party. So that is enough. Now, let's come to the way forward, because the court has previously pronounced itself on this matter and actually ordered the president to swear in or gazette all the 41. It is sad that one passed on, so it was only 40 to be sworn in. So the action the president took was basically what he's been doing the past 2 years, if not the last 7 years. Complete blatant disregard of court orders and following the rule of law. In fact, the irony was, as he was giving the statement to the 34 judges sworn in, he was saying and he was advising them to uphold the rule of law. And I think to every observer, they would see that was like a mockery. Does he himself do that? So the step taken by the judges and the Magistrates Association is basically a step to show that the fight will continue. Constitutionalism is never got on a silver platter. It will be wrong for them to give up. It will be wrong for them to sit and say everything's okay. Of course, we know the outcome. The court will basically, or may, with high chances of success, reiterate the previous court order that says the president has no powers and he has to swear in the 6th. The only difference would be, do you think the president can be able to follow? That is a question. And he's proven over and over again that he seems not to care. He seems not to give a damn about court orders. But I'm happy the judges and the magistrates are taking the fight on. In fact, I would expect the court to give a declaratory order and say they should be considered as duly nominated and duly appointed. I wish to draw the attention of viewers to the case of Justice Warsame, when he was nominated by the judges to sit in the JSC. And I remember the question was whether Parliament can vet a nominee picked by the judges. And the president and his team were for the idea that he must be vetted. And remember, it went to court and an order was given, and Warsame was duly gazetted and sat without going through the vetting. I hope the same can be the trajectory, so that if we can find a way in which the 6 automatically, through a declaratory order from the High Court, they can proceed, except that the politics of the 2 arms of government comes to play.
But then, you know, everyone was looking at what the president had to say when he rejected the 6 names and, you know, forwarded the 6 names to the JSC. But according to the president, his argument was based on the, you know, integrity issue, which had been detailed by the National Intelligence Service and other security agencies.
Now, that is a very good concern. In the NIS report, question would be, was it made available to to the JSC? Because during the interviewing, which was done very publicly in a very open manner. In fact, I remember a former commissioner representing us as lawyers, Mercy Deche, was on set, I think 3-4 days ago. And I watched her asking the same question. What allegation did we not go through? Did we not raise, or did we not even do it publicly? In fact, not even on camera. It was very public. So if there was any allegation, and that is the mischievous nature of such an allegation, that there's an NIS report, that report, if it is available, nothing stops the president's team from tabling to the JSC as at the time they were conducting. And does it not concern you that, curiously, you look at the judges left out, or the nominees left out, are mostly those that are considered to be independent-minded? So if we talk about a report that is not made public, and I'm happy even the petitioners who've gone to court suing the president gives a chance for the same to be brought before the court of law. So I hope that during the petition proceedings, the same can be laid bare. However, what implication does it have? It doesn't have any implication. Once the JSC has pronounced itself and they have considered all petitions, all allegations, and they approve that this can be appointed, that is it.
All right. And you know, political pundits and also some lawyers like yourself, Wakili, have actually said that the continued attacks by the president on the judiciary through innuendos is does not only affect the individual judges, the 6 who've been left out, but the entire judiciary and the rule of law. Because back then, during the leadership of the then, the immediate former Chief Justice David Maraga, he saw the need through the JSC that the country needs 41 judges to be promoted so as to fill in the gap. So the president goes ahead during Martha Kome's time, the CJ, and appoints 34. So that means these other judges who've been removed from these other lower courts to upper courts have also left a gap. So what is the way forward even for the CJ? Because the only thing we saw was a statement urging the president to appoint the remaining 6 so as to fill in the gap.
Now, the first fundamental issue you've raised is that what does it portend for the rule of law? I can confirm to you that it is so dire. Remember, the president is the symbol of national unity. The president has the highest responsibility to guarantee that we are able to stand by the rule of law. So if you have a case where that is not, a court order is not respected, what should make myself or any other person to respect a court order? So that is the first fundamental issue that as a country we need not just to lay or whatever, like we can't just let it lay. Secondly, the former Chief Justice Maraga made it clear, just not about the backlog, but it is also about the integrity of the judiciary. Mm-hmm. One question that was raised was, what do you think it will be for a petitioner or a client to appear before the 6 judges? Don't you think they've already sown a seed of doubt in the eyes of the public about these 6, yet there is no single allegation raised about them? So it is not even just beyond the gap. What happens? Does it mean that you say they cannot qualify to sit in the bench, that is at the Court of Appeal, but they can qualify to sit in the High Court? That is impossible. If I have integrity issues, for example, at the magistrate level, at the judges level, at the Court of Appeal level, they are all the same. So it is a very pertinent issue, and that shows you the hypocrisy in this kind of a situation. In fact, according to the statement, and I would want to empathize with the CJ, but the CJ must stand up. This is the biggest test. A Chief Justice never gets a lot of opportunities to test.
In fact, Wakili,
the first Chief Justice after the new...
Sorry for cutting you short. Just finish your statement.
Okay, I say that the tests for Chief Justice are very few. For Willie Mutunga, it was the presidential petition, the petition of 2013 and the independence of the judiciary setting up. For Maraga, it was 2017 election petition. And for the current Chief Justice, it is the first real test to be able to show whether she believes in judicial independence and growing the strength of judicial spine, because this one, they cannot compromise.
Right.
And I think if President chooses not to appoint the 6, what will make you have confidence that even if they do interviews to fill in the gap of the remaining 40 in those other courts where those that have been promoted have emanated from, do you think then the president will have the desire to even appoint them? You know, that is a question that the Chief Justice needs to answer. In
fact, Wakil was about to ask you about the future of these 6 judges, because the president says he was relying on the NIS report when it comes to their integrity. And so they've not been promoted, if I may use that word, to other courts that the JSC has proposed for them to move into. And they're still serving the country. So where does it leave the 6 judges? Will they continue serving as judges? And we're supposed to make the decision as to whether they are to continue serving or not.
Now, and that is what brings to the hypocrisy I'm talking about. If indeed there's any integrity question against the 6 judges, the procedure or the law is absolutely clear on what needs to be done. Bring it before a tribunal, set up a tribunal to investigate them. If indeed these allegations were true, if indeed there are allegations on integrity that can be substantiated, nothing would have prevented the president or his team to set up a tribunal to investigate, because it really looks bad on where you say this judge can't sit in the Court of Appeal, but can still sit in the High Court. And remember, most petitions, very significant petitions on public interest, whether constitutional, commercial, public or criminal, they all lie in the High Court. They start at the High Court, most of them. Remember, there are 2 magistrates, senior magistrates, who have not been promoted to sit at the High Court level. What happens to their courts? They have already existing matters they are handling. Look at Justice Odunga and Justice Professor Joel Ngugi. They are the ones who sat and determined on the issue of the BBI. So if you say that they have integrity issues, what does it portend of them continuing to listen to matters? And that's why I'm saying it purely tells you there isn't much can be adduced against. And these are judges with impeccable track record. I think I have appeared before one or two, and I can confirm that if indeed there was anything, I wouldn't think any of this would have lasted more than a day in the judiciary. Let's just say, because they have been given so many rulings that are considered to be adverse to the government of the day, that of course makes them an enemy. But that can only be politics. But when it comes to the true rule of law, or if you're to follow the facts, I don't think there's anything that can be substantiated. JSC would have been given the same, and at the same time, they wouldn't be sitting at the High Court as we speak. All right,
Wakili, I need us to wind up this conversation, but I have only two questions, important questions left for you. So kindly, if possible, you can answer them in a summary within the minute I'm giving you. So there are two critical questions I need to ask you. One, it has been looked at as the 6 who've been left. 2 of them were among the 5, were in that 5-judge bench that gave a ruling. So it's been looked at as if the president is actually repaying, paying back those 2 judges. I'm talking about Justice Professor Ngugi and also Justice Odunga. And the other question is, we are seeing like the president has started on a wrong foot with the new leadership of the judiciary. I'm talking about the new Chief Justice Martha Koome, because during Madaraka Day, there was an attack on the judiciary in the presence of the Chief Justice. Again, now, days later, the president decides to appoint 34 judges and leave the 6. What sort of relationship do we expect the president to have with the new Chief Justice?
A quick answer to the two. The first question is that I don't think it is a repay back for the BBI ruling, because he refused to gazette all the 40 judges since 2 years ago. So it has been a long-running dispute. I think it is just beyond this decision on BBI. Inclusive, I think for the 2 judges, if you look at the innuendos from the government operatives, there's always been a feeling that they are independent-minded and always giving rulings considered to be against the government. So not just the BBI. The BBI was one among others. So that is the fact, because 2 years is a long time to just say this is the matter that has costed them being gazetted. Number 2, on what happens, I don't think it is an indictment on the part of the president. At least he's made it clear. He doesn't respect court orders. He doesn't believe in independence of the judiciary. He's made it clear, and I don't think there's a new discussion about him starting on a wrong foot. It's just a question of finishing on a legacy that he has been able to sustain, that he does not believe in the rule of law. The question should be, how does the new Chief Justice react and deal? Because, in fact, it is all about the Chief Justice now. How does she react? And that's why there was underwhelming response from her office when they gave a partially mixed statement, saying they urged the president, at the same time say, you could see the mixed messaging. So I really empathize with the Chief Justice, because this is the real test. And it will be seen as we go to the next election. Remember, we are going towards a very tough election, and succession politics always spill over to the court process once it comes to presidential petition. And I think this is the test that will determine whether the Chief Justice will have the spine and her team to be able to sustain an onslaught from an executive that has been consistently against the judicial independence.
All right, Wakili, asante sana. That is Joshua Kiptu, is a lawyer, just trying to explain for us this whole developing story when it comes to the decision by the president not to appoint 6 judges and goes ahead to appoint 34 judges. And the Judiciary and Magistrates Association, Magistrates and Judges Association have actually said they're moving to court. So once we get the latest details on that, we shall be giving it to you here on KTN News. But then time and speed will be critical for politicians as they traverse the country in campaign.